The goal of this video is to help you understand the important differences between the Articles of Confederation and the Constitution. It would help, but it's not entirely necessary, but it would help if you have the PDF that first page of which appears on the screen right now. That might help you understand some of the points that are made later in the video. Also, the AP exams will sometimes quote directly from the Constitution or the Articles of Confederation, and if you can say to yourself that you have actually read various passages in both of those documents, it would be helpful to you in the long run. So I encourage you to download that PDF and read it as you go through this video, but it is not 100% necessary. The first section of this assignment looks at these sections of the two constitutions in order to investigate the general nature of the Union as described in those documents. First of all, regarding the general nature of the Union, in the Articles, the preamble mentions that it is a perpetual union between the states and then lists the states. There is no reference to the people, just the states that are creating the Union. Article 2 of the Articles of Confederation specifically state that the states retain their sovereignty, freedom, and independence. And Article 3 of the Articles of Confederation describes the Union merely as a league of friendship. If you add it all up, then really what you have here is a treaty among sovereign states. And as we know in the real world, sovereign states break treaties all the time when it suits them, when it's convenient for them, and they are often not considered as permanent. The Constitution, on the other hand, begins with the famous three words, "We the people." It's important to mention it does not begin, "We the states." Article 7 of the Constitution specifies that the Constitution is to be ratified by state conventions, not by state legislatures. That means not state governments. And then Amendment 10 reserves, the last amendment in the Bill of Rights, reserves certain powers to the states, but does not make any mention of sovereignty. If you add all of this up, it is clear that the Constitution was created in the name of the people. It was ratified by the people, not state governments. And therefore, it is a social contract among the American people, not an agreement between states. And a social contract is much more permanent and long-lasting compared to a treaty. The second major difference between the Articles of Confederation and the Constitution is the powers of the national government. Both documents list the powers of Congress, but in the Constitution, that list is much longer. Specifically, under the Constitution, Congress is given several important new powers, such as the power to tax, the power to regulate commerce among nations and states, to make naturalization and bankruptcy laws, to punish counterfeiting, grant copyrights and patents, raise and support armies, govern the National Capital District, and to make laws necessary and proper for carrying out its powers. This is an awful lot more power than the Congress had under the Articles, and we will come back to many of these powers several times throughout the course this year. In addition, some of the powers that were once held by Congress under the Articles of Confederation were transferred to the new office of the president, such as that person acting as a commander-in-chief, the negotiating of treaties with other countries, and the nominating and receiving of ambassadors. Section 3 of this assignment looks at these particular sections of the Articles and the Constitution to get some detail on how the legislative branch was reformed in the Constitution. The Constitution also features a completely reformed legislative branch. Under the Articles, Congress was not only weak, but it was unicameral, and every state had equal power, that is, one vote per state, which was deemed to be very unfair by certain states. Under the Constitution, Congress was completely reorganized. It is bicameral. There's a House of Representatives, where representation is proportional to the population of each state, so larger states have more votes. Also, the people directly elect the representatives, giving the people a voice under the Constitution that they did not have under the Articles. There is also a Senate, which is more like the old Congress because each state is equal to each other, 2 votes each, and the senators are appointed by the state legislatures, just like they were under the Articles Congress, giving the states direct input into the national laws. This bicameral arrangement is a result of the Great Compromise. Don't forget that is highly likely to show up on the AP exam. We're about halfway done, so if you're in the mood for a break, here's a fun fact about Mr. Morris. You know how Michael Jackson does that high-pitched woo-hoo in a lot of his songs? Mr. Morris taught him that. True fact. Part 4 of this assignment looks at the relevant sections of the Articles of Confederation and the Constitution to examine the executive branch. Another major change was the addition of an executive branch, a true executive branch. Under the Articles, there was no executive branch. There was simply a subcommittee of Congress, which it was empowered to manage the affairs of the government, and it had a presiding officer called a president with a one-year term, and it rotated among delegates from various states, but that did not amount to a true enforcement branch. A true enforcement or executive branch was created under the Constitution, headed by a president with many important powers. The executive power, that person is elected independently of Congress for a 4-year term. His compensation cannot be changed while he's in office. He appoints the heads of departments and inferior officers. That means today, like the Secretary of State, Secretary of Defense, that kind of thing. The president can recommend legislation and exercise various other powers over Congress, and his overall duties is to take care that the laws be faithfully executed. And we will come back to this when we get to the executive branch later on in the course. Part 5 of this assignment looks at the relevant sections of the Articles of the Confederation and the Constitution to look at the judicial branch. Another major change was the creation of a judicial branch, which barely existed under the Articles of Confederation. Congress could create courts for various limited reasons in certain kinds of disputes, but it rarely did so. Under the Constitution, it creates a permanent and separate and independent judicial branch with a much more extensive jurisdiction over not just maritime cases and interstate disputes, but cases involving federal law, federal officials, federal government, treaties in foreign countries, and disputes between citizens of different states. Part 6 of this assignment compares national versus state power in the two documents. On the question versus the power of the national government versus the power of the states, the Articles was limited to basically a statement that said the authority of Congress would, quote, inviolably be observed by the states. However, in actual fact, they were not. States retained full sovereignty and frequently disobeyed Congress's laws. Under the Constitution, there are a variety of provisions that subordinate state power to federal power. The Supremacy Clause states that the Constitution, treaties, and federal laws are the supreme law of the land. State judges are bound by what the Constitution says, no matter what a state constitution or state law may say. And the Constitution requires that not only members of Congress, but all state, legislative, executive, and judicial officials swear an oath to support the Constitution. And finally, Part 7 of the assignment looks at the amendment process for the two constitutions. And finally, another important change was the process of amending the constitutions. Under the Articles, unanimous approval from all 13 states were required in order for an amendment to be passed, and therefore it was never amended. This has something to do with the fact that it was eventually just completely scrapped and replaced by the Constitution. The Constitution, on the other hand, could be amended more easily, not easily, but just more easily. It's still hard to have a constitutional amendment gotten through. It takes 2/3 of Congress, 3/4 of the states. It's difficult to get that, but it's more possible than under the Articles. It is more flexible than the Articles of Confederation proved to be.